Good morning and welcome to our Board of Adjustments meeting for Wednesday, June 14th, 2023. First order of business, we're calling to order approval of the minutes for May 2nd, 2023. If everybody's looked over the minutes, I'll take a motion to approve them. Have a
Motion to
motion.
approve as presented.
And have a second. All in favor? Unanimous approval. First, second. Old business, we had an application for a setback last meeting, and I think that was forwarded to this meeting. Is that correct?
Yeah, for May
Clerk.
2nd, Mr. Chairman, for May 2nd.
Mr. Chairman, my recollection was that we realized prior to that meeting, we were only going to have 4 board members. Since variances require a 4/5 vote, we gave all the pending variance applicants an opportunity to continue the hearing until we have 5 members, and I believe,
They chose to wait,
yes, sir.
and that's why we're here now.
Yes, sir, Mr. Chairman.
So actually that we don't have any new business, we're here for continuation of old business. This is a matter that's not come up before since I've been chair for a long time. One of the board members asked to address the board into the minutes, a comment on a previous hearing. I want the attorney's remarks on this, if it's appropriate or not.
Wants to comment on this particular variance
No,
application or
it's on
something?
a previous hearing.
Yeah, I wish to make a comment about it regarding some good work done by our code enforcement officer, David Emerson. I just have it'll be of interest to the board concerning a case we had late last year.
Does it pertain, not knowing what you're going to say, it's
Yeah,
kind of hard for me to answer that question.
Yeah.
If it pertains to the subject matter of, when you say a case, was it a variance or an appeal?
It has to do with a variance that we reluctantly passed due to the negligence of a contractor. And I believe it was Steve Uhas who asked, can the board or the planning code enforcement people not take any action at all?
My point is, it has nothing to do with the hearing that we're called for today.
That's absolutely correct.
Mr. Chairman, that would be in your discretion whether you would like to allow that type of,
I don't see the point in it at this hearing. If you want to bring something up on a particular code enforcement officer, then that should be brought up to the department and the department head. And if that's not satisfactory, then to the council.
That's fine. I'll huddle with our planner after the meeting. Thank you.
Okay, very good. All right, let's continue then with the case at hand.
Mr. Chairman, as you indicated, this is a variance application that the applicants are Mr. William and Miss Lynn Messenger. Am I saying that correctly? I believe Attorney Greg Cleva, an upstanding member of the Brunswick County Bar, is going to be representing them today. We're going to go over kind of the procedural requirements. You guys heard this before, but I think it's important to remind us all, including myself, as well as the applicant, each time a variance application is heard. This is what's called a quasi-judicial proceeding, which means we will conduct it to ensure procedural and substantive due process of all involved. We will use the North Carolina Rules of Evidence as a guideline, but we won't follow them necessarily as strictly as we would or a judge would in a court of law. The applicant is entitled to a fair and impartial decision-making body, which essentially means you can't have your mind made up, and you are duty-bound to base your vote on this application solely on the competent, substantial, and material evidence that's received during this hearing. I need to ask you all as a group a few questions before we get started, then I'll describe the process we'll go through, And Madam Clerk, as usual, if all of the responses are in the negative, please so note in the minutes. So let me start by saying, does anyone on the board have a financial interest in the subject matter of this variance application? And the property location is 1807 West Oak Island Drive. Anyone have a financial interest in this subject matter? Okay. Has anyone had any ex parte, and by ex parte I mean conversations outside of this hearing with any staff member about the subject matter of this variance? Has anyone had any ex parte discussions with the applicant or someone associated with the applicant regarding the subject matter of this variance? Okay. Does anyone have a close family or business relationship with the applicant? Has anyone made a site visit to 1807 West Oak Island Drive for the purpose of assessing this variance application? Okay. Can any of you think of any reason why, whether I've asked you or not, that would preclude you from being fair and impartial and basing your vote solely on the evidence we hear during this hearing? Okay. All witnesses that wish to provide testimony will be sworn in and subject to cross-examination and subject to questions from the board members. We will go in the following order. Mr. Kirkland, on behalf of the town, will introduce the item. He will be subject to cross and questions from the board. Then we will hear from the applicant. Whoever testifies on their behalf will be subject to cross-examination and to questions from the board. And then if any other party is sworn in and has standing, we will hear from them as well. I would recommend that we allow any cross-examination to occur before we have board questions. That way we don't keep going back and forth over and over each other, and it's more orderly. Having said that, you as the decision-making body have the right to ask any questions you'd like at any time prior to closing the evidentiary portion of the hearing. Are there any questions of me, Mr. Chairman, or board members?
I don't. Does the board have any questions?
Ask all those who intend to provide testimony to come forward and be sworn, or do you prefer them just to stand, Lisa? Are they going to testify? No, I'll present on their behalf. Okay, they may be asked questions, so so if you don't mind, Mr. and Ms. Messenger, do you mind being sworn in, just in case the board members have questions of you directly? And as an officer of the court, you don't have to be sworn.
Yes, that's fine. Squeeze it. Okay, left hand on the Bible and raise your right. Solemnly swear that the evidence you give to the Board of Adjustment during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God.
Mr. Cleaver, do you have a copy of the agenda packet? Okay. Would you just take a quick look at pages 11 through 21? I believe that's the materials associated with this item. Oh, excuse me. Pages 9 through 21.
That's fine.
Okay, do you need that back?
I do not. Nope, keep all of it.
We're going to mark pages 9 through 21 at this point as Exhibit A, and then after Mr. Kirkland authenticates it, we'll introduce that and give you an opportunity to object if you'd like, Mr. Cleaver. Mr. Kirkland?
Ready?
Yes, sir.
Okay. Morning. You have before you a application for a variance into the side setback. Property is located at 1807 West Oak Island Drive.
You have your information in your agenda packet. This is a variance from a side yard setback. In this instance, it's a corner lot, so that corner lot side yard setback is 10 feet. The applicant's requesting a 3 feet encroachment into that setback area. The elevator is existing, it's already on site and been constructed. You have some information in your agenda packet as far as the zoning. The zoning is R6. The zoning is similar to everything that's around it. You also have a sketch plan or a site plan in your agenda packet showing the location of the elevator and the orientation of the structure on the property. Very quickly go over the variance standards. So these are the things that the Board of Adjustment must find in order to grant a variance. You have to find all 4 of these standards in order to grant a variance. It's a lot, but I'll read them out for your benefit and the benefit of everybody in the audience as well. First, that an unnecessary hardship would result from the strict application of the regulation. It is not necessary to demonstrate that in the absence of a variance, no reasonable use of the property can be made. That the hardship results from conditions that are peculiar to the property, such as the size, location, or topography, hardships resulting from personal circumstance, as well as hardships resulting from conditions that are common to the neighborhood or the general public, may not be the basis for granting a variance. A variance may be granted when necessary and appropriate to make a reasonable accommodation under the Federal Fair Housing Act for a person with a disability. That the hardship did not result from actions taken by the applicant or the property owner. The act of purchasing property with the knowledge that circumstances exist that may justify granting a variance is not a self-created hardship. Excuse the 18 there, that's a typo. Then that the requested variance is consistent with the spirit, purpose, and intent of the regulation such that public safety is secured and substantial justice is achieved. A variance requires a concurring 4/5 vote of the board in the affirmative. The burden of proof lies solely on the applicant to prove that they meet those 4 standards for a variance. Once again, very briefly, the applicant has requested a variance to the side setback requirement for elevators at 1807 West Oak Island Drive. Zoned R6, subject to a 10-foot side setback on the side street. And the applicant is requesting a 3-foot encroachment. Here's oriented a little weird, but you can see this is the site plan that you have in your application packet. You should turn that this way. The north arrow you can see is facing towards the left in this instance. You can see it's very small. It's marked in the center of the footprint of the building where the elevator is, and there's a little arrow pointing to it. You can see where it encroaches into the side setback line there. That's that dashed line. This marked MBL. This is for minimum building line.
I'm sorry, Matt, just for me, can you show me the footprint of the elevator?
Yes. I don't have a.
You could just,
Come around and show you guys.
Yeah.
It is, so you see elevator, and it's pointing to that little box right
Okay.
there. It's a small box right beside the word porch. If you look at the footprint, I'll come point it out to everybody for you.
That bar-
There, that box right there, so you've got an elevator, the word elevator, and a little arrow pointing
Okay,
to it.
got you.
Oh, yeah, there you go. We're on screen.
Right there.
Turn around.
I was just letting Matt, excuse me, Greg.
Yeah, there.
See where we're
Yes.
talking about.
Right there, that little box.
Ms. Stites, for the minutes, it's in the lower portion of the site plan. It shows the lot lines, and mid-left, there's the word elevator with an arrow pointed to a little square footprint.
Does everybody feel like they know about on the property where this is, based on this plan? And once again, we'll have the variance standards here at the end in case you have questions about any specific standards and how it relates to this case. I won't reread them for your benefit, but we'll have them up here on the screen in case you need to reference them back pretty quickly. These are also in your agenda packet as well. So that's the gist of the case. If you have any questions for me, I'd be happy to try to answer them. Otherwise, we'll have the applicant come up and present their case for you.
What's the setback on that particular side yard?
10 feet.
And how much encroachment are they charged with?
On the slide right here, we have the 10-foot side setback on the street. Applicant is requesting a 3-foot encroachment.
In other words, it's 7 foot back from the right of way.
That's correct. That would be 7 foot left. after the 3-foot encroachment. That's right.
Is that a diagonal line across their footprint of the elevator, or is it?
It's a straight line, yes, sir. Appears to be roughly at a right angle with the street.
Is that an enclosed all-weather lift?
The applicant can answer questions about the construction details of the lift.
Okay. So you haven't visited the site?
Other than to post the sign, I haven't done any inspection of the site, yes, sir.
Why does it say tall wood fence? Is that how tall is that tall wood fence next to the elevator?
Once again, these are great questions for the applicant to address about the specific construction and details on the ground for the site.
Those are survey notations.
Yeah, there's a survey notation for, it says tall wood fence as well to the left corner.
And none of this drawing is town originated, all this is survey notations
This is
provided by
all-
the applicants.
That's correct.
Okay. I have no further questions for Mr. Kirkland. Any other board members? Thank you.
No questions at this time, Mr. Chairman?
Mr. Cleve, any cross-examination of Mr. Kirkland? All right, Mr. Kirkland, would you like to offer pages 9 through 21 of the agenda packet, evidence as Exhibit A?
I would.
Any objections, Mr. Cleveland? Okay. Mr. Chairman, I recommend we accept pages 9 through 21 of the agenda packet as Exhibit A without objection.
Very good.
Received? Okay. All right. Mr. Cleveland?
So state your name and address, please.
Yes, sir. My name is Greg Cleva. I'm an attorney with Gettings and Cleva. Our firm is located here on Oak Island at 8721 East Oak Island Drive. Good morning. Again, I'm here on behalf of the applicants, William and Lynn Messinger, on their application for a variance into the side setback of their property located at 1807 West Oak Island Drive. The evidence so far, not to be repetitive, but we are here on the variance application, and up on the screen, and I'm assuming in front of everybody, are the requirements or the standards that must be met for issuance of the variance. And I believe that what we will present this morning will be adequate to gain favor and grant that variance. In going through them, the standards, that is, as we said, I'll address the first two now, are the unnecessary hardship would result from the strict applications of the regulation, and the second one is that there's a necessary and appropriate reason for the variance to be granted. The homeowners purchased their property and they built the home there. One of the homeowners, Miss Messenger, has a medical condition. She has osteoporosis, and it limits her in her ability to carry things and lift things and walk with heavy things, and ambulate up and down stairs. I believe in the packet we enclosed a letter from her physician stating that doing such things could increase her risk of fall and thus fracture and injury. So that physician had recommended that a lift be installed at their house. They went along with that. They retained the services of a elevator contractor called Sunset Lifts out of Bolivia, and we attached a copy of the contract that includes, or included in the packet, is a copy of their purchase contract for the installation of the lift. As part of this agreement, the contractor was to obtain the permits necessary to construct the lift, and that was paid for by them. So in good faith, they are relying on their professional contractor to fulfill the obligations that he had, which was also going to the town to get a permit. For whatever reason, and we still don't have a good answer on this, but for whatever reason, that was not done. A permit was not applied for. But the construction of the lift continued and was built, and the only reason why the applicants became aware of this situation was they received a notice from the town on January 30th from Ms. Horn saying that the construction of this lift was done without a permit. They inquired and found out that the permit wasn't issued and went back to their contractor and had some back and forth with them. Since then, Mr. and Ms. Messinger have been advised that a permit was issued by the town. I am not able to verify that. I have not received a copy of a permit, but that is what the contractor is telling the applicants. The applicants, as I said, they are the owners of the property, and they didn't construct this lift, themselves. I understand that being a homeowner, you're responsible for what goes on your property, but at the same point, that's the reason for retaining professionals to do things. They had every belief and understanding that what they were doing on their property was proper, and they weren't trying to undermine anybody in the town. They weren't trying to install this at night undercover. This was done right out in the open, and their property is right on the main road of West Oak Island Drive and 19th Street. So I believe that the strict application of the ordinance to impose the 10-foot side setback on their property, given the situation that they didn't knowingly do that, okay? They didn't knowingly and intentionally say, put it here. This was where they had wanted it. The contractor put it there under their belief that a permit was issued by the town. So we believe that moving that having them have to move that to a different area of the property would be a hardship for Ms. Messinger, as she would have to ambulate longer through the house while she's carrying things such as groceries or luggage, because they are not permanent residents here. I should have mentioned that earlier. It's mine. They do not live here permanently. This is a second home, and let me just get their address. Sorry, I should have had that. They reside at 3740 Squirewood Drive in Clemens, North Carolina. So they're not here all the time. So when they come down, they have to move through the house and bring luggage. Also, as we said, the setback on that corner lot is 10 feet. The interior lots are normally 8 feet. This encroachment, while it seems like a third of the setback, which if you could look at it that way, I believe that if it was a side setback issue on an interior lot and the exact same item was constructed, we would not be talking about a 1/3 encroachment, but we would be talking about a 1/10 encroachment, because it would only be a foot if it was an interior lot. So there's 7 feet left of setback, and this is not through the whole length of the home. It's just to that one area where the elevator is. The next area that we would address was, well, I think I said it in there, but hardship not resulting from actions taken by the applicant. Again, I'm not saying that you bury your head in the sand and don't do anything and not take responsibility for what you do, But I think every situation is different. It's not black and white. It's not just checking a box. When you hire somebody to do something and it's a company that's existing in North Carolina and they say they're going to get a permit and it's on their contract and it's constructed and there's no notice to anybody during the construction or no violation or stop work order, it's hard for a homeowner to say, oh, I did that myself. Or I think it's hard to say a homeowner did that themselves. And I'll be frank with you, I think if Mr. and Ms. Messinger constructed this themselves and said they were going to get a permit and they were going to do it and they actually themselves were constructing it, I think they would be in the wrong. But I don't think that they're in the wrong given the fact that they didn't construct that.
Mr. Kleba,
Sir.
I'm looking at, on page 18 of the agenda packet. And under the description, do you see that?
Yes,
The very last sentence reads, "Permit will be done by Sunset Lifts,"
yes,
and that was from Sunset Lifts?
yes. If you look at the top left corner of page 18, it's on the letterhead of Sunset Lifts with an estimate, services vertical platform lift,
Right.
and permit will be done by Sunset Lifts. And you can see the amount that was paid on that exhibit this is not a friend doing something for someone. They paid a significant amount of money, which they did pay in full to get this, and so I believe that they were relying on that service. And so, as I said, I believe that if they had constructed that lift themselves, if they had done it themselves, I think that we wouldn't be here. But this is not something that they did themselves. They were in good faith relying on what was done for a reason, not just to have a lift to have a lift. They have an actual need for it.
Well, I was going to ask you that question in a moment too, but also on page 18, if you look beneath the description, it has the 80%, 20%, allow 6 to 8 weeks for delivery. Then it says, or it reads, "Doctor's note will take care of the sales tax." Is that doctor's note related?
I believe the doctor's note there is the doctor's note is not attached, but I believe that it's from it was referring to the Atrium Health.
That's page 19.
That's
isn't it?
page 19. It's the same condition by Dr. Southern. So there's a medical need for the lift.
I didn't mean to interrupt you. It's just, you referenced that the contractor was going to take care of the permit. They told your clients that. And I wanted you to clarify if this indeed was the representation from Sunset Lifts to your clients.
Yes, that is the representation, that is the contract or the bill for services that they were presented with and what they paid for.
Thank you, sir.
Okay. And again, I think the last thing, the last provision, the intent of the regulation to promote public safety and promote public justice.
Mr. Cleaver, hold on. Can we click to that next? All they have on their screen are criteria 1 and 2. There you go. Thank you.
Yes, I think in 1, 2, and 3, I sort of addressed at the same time just now, but I'm addressing number 4 now, where the variance being consistent with the spirit, purpose, and intent of the regulation, such that public safety is secured and substantial justice is achieved. In my packet, I outlined and made a statement that I'm aware that the building code and the setback code and regulations that exist within the town do so to make sure that structures are safe and to make sure that they are done properly and we don't just have random things popping up all over town. But in this case, there's no allegation or no violation saying that the lift or anything around it was improperly constructed, meaning it's not safe, okay? Such that it would constitute a danger to the user or any guests or renters or anybody who would use that lift. That's not what we're here for. We're here for the setback encroachment, for the setback issue. There's no line of sight issue here. with where that encroachment or the structure encroaches into the side setback. It's not causing any issue with any of the surrounding properties. It doesn't interfere with the use of the right-of-way on either 19th Street or Oak Island Drive. So in promoting safety or public safety and promoting justice, public safety I don't think is an issue here. I think the issue is really substantial and promote justice. That's why we have these boards, and that's why you all serve, is so that we can talk about things and make, decisions about them. This is not going right up to the property line. This is not going right up to the setback. This is, if I'm to say once again, if this was on an interior lot, this would be a 1-foot request. I do have some, and I didn't have them in the packet, but I do have some color photos so that you all can see what it is. I didn't know if anyone did a site review, so I can pass those down.
Mr. Eads?
I made 6 copies. I have original photos that you all can look at.
Introduce these, Exhibit B,
Yeah, that's fine.
that projection.
But,
Greg, just let me
Yep.
mark all of these and hand them out.
no, you're fine.
So Exhibit B is going to be a 2-page, well, I recommend we accept as Exhibit B, Mr. Chairman.
Yes.
A 2-page document that has 2 pictures per page for a total of 4 pictures on 2 pages. Is that accurate, Mr.? Chairman?
Yeah, I guess it is.
Okay, thank you, sir.
I'm including the pictures.
Let's wait till they get them all, if you don't mind.
Knowing everybody's got them and we're good. Okay. I'm including the pictures because I think that the photos kind of speak a little bit better and give a more accurate depiction of what we're talking about here. The side setback issue that we're talking about is, there's the wooden structure there, that's the enclosure for the lift, and you can see the lift on the right side of the house. And that's the view as if you're looking from Oak Island Drive. So the 2 to 3 feet would be in the area of the driveway. And again, there's no interference with, or any visual obstruction from any other property owner, or any interference with the right-of-way. I know that we had given notice to the other property owners, and just to represent to the board, I haven't received any phone calls, correspondence, emails, or anything in objection to the application. I know
To
that's-
clarify, Mr. Cleaver, you gave them notice of this variance request?
Yes, as part of the application, I believe it was page, let me go back in here, I think it was page 15. The list of owners there, I listed what their addresses, were, and, I didn't send that out, I just included that in the application. I do know that the applicants had spoken to some of the other owners who they're friendly with around there, and there was nothing presented to them as an objection. I didn't mean to imply that I sent notice of the application, I just put those property owners in there, and those list of property owners is, it's 100 feet circumference from the property, so there's even people on the other street who I included to make sure that there was enough notice, enough people who could meet who could have a say if they wanted to at the petition, but, or at the application hearing. But the lift is there, that's what it looks like. The only other thing I want to say is that the lift doesn't extend farther than the front of the house. If you're looking at the house from Oak Island Drive, there's a portion of the house all the way to the left that actually extends a little further, and this only goes as far as the porch and up to the driveway there. So it's approximately 5 feet in length by, I guess it would be the 3-foot encroachment. So it's a 5-by-3 area that we're seeking relief from. That would be my showing. I'd be happy to answer any questions that any of the members have.
please.
Yes, sir.
The setback from the elevator itself, does that include the fence that protrudes just beyond the elevator?
Let me look at the thing. I believe it does.
Yeah, that's the fence from the street as a,
Yes, I believe it does. On the page 20, where it's indicated tall wooden fence,
Yep.
it's right next to the, abuts right up to the elevator on the same line. There's nothing between that. If it is not the same, I believe then the encroachment would be 3 feet by the width of that board. So at the most, I would say 3 feet 4 inches, or 3 feet 6 inches by the width of that post.
I have a question, Mr. Attorney. The Exhibit B, the first picture, I'm looking at the drain gutter. That typically denotes, actually, this would be to the left, the right-of-way. Is that accurate?
The drain gutter, yes?
Yeah, it does. So it does picture that you're not talking about any serious encroachment on the more than adequate right-of-way here.
No, that's part of what I was addressing, that there's no, at least the way I'm viewing the matter, I don't see any infringement or effect on the town's right-of-way at all.
Mr. Cleaver, do you mind if I ask your clients to just verify a few of these documents?
Yes, sir, that's fine.
If Mr. Messenger could come up. We'll hand him your agenda packet.
So this is the agenda packet, and I can help you.
State your name and address, please.
My name is William Messenger, and my permanent address is 3740 Squirewood Drive in Clemens, North Carolina.
Mr. Messenger, on page 18, you may have heard me ask your attorney about this. Sunset lifts the estimate. Do you see where it reads accepted by?
Yes,
Signature, sir?
yes, sir.
Okay, thank you. That's all. I just wanted to authenticate that for the record, since it's technically hearsay.
Yeah.
And then if, Ms. Messenger, do you mind coming forward? Greg, will you turn to page 19, please?
Yes, sir.
Ms. Messenger, do you see page
If you'll
19?
state your name and
Oh, sorry.
address,
Oh, I'm
please.
sorry. Lynn Messenger, 3740 Squirewood Drive, Clemens, North Carolina.
Thank you.
27012.
Ms. Messenger, do you see the letter from Atrium Health on page 19?
Yes,
Okay, and do you recognize Miss Betsy Wicker Southern? She looks
yes.
like
She's
she's
the
a,
physician I see
okay.
in the osteo clinic, yes.
And did she write this letter on your behalf?
Yes, she did. I talked to her personally on the phone.
Okay, and you, I don't want to use the word suffer, but unfortunately, you have to deal with the description of these health concerns.
Correct. There was a period of time when I was first diagnosed that I was totally on a walker,
Yes, ma'am.
and I was not able to come down here at all. I was told not to lift over 5 to 8 pounds. So like carrying a 6-pack of drinks into the house, I would have to bump it up one step at a time, because I am able to drive. So if I came down here by myself, it would take me a good hour and a half using all the safety precautions to get things out of my car and into the house.
Yes, ma'am. I just wanted to authenticate that this letter was written, sent to you.
Yes, it
And it
was.
accurately reflects your medical condition
Yes, it
as
does.
described.
Yes.
Thank you, ma'am. That's all. Does the board have any questions of Mr. Cleveland?
I have one more question regarding the disability. Do we have anything other than the letter? Does the applicant have disabled license plates?
No, she's not, doesn't have a handicap license plate.
Okay, I was worried, I was wondering about that because we can make exceptions under the Fair Housing Act for a
Yes.
person with a disability. That's why I asked that question.
Yes, sir.
But she doesn't have to have a disability license tag to fall under that category.
Not for the board to recognize that.
Any other questions?
I have none.
Thank you, Mr. Cleveland.
Thank you.
Well,
Thank you
Matt,
for your
did you-
time.
you don't have anything? All right, at this point, we're going to suspend the evidentiary portion of the hearing. We're not going to close it in case there are questions that need to be answered as you deliberate. The criteria that 3 and 4 are still up on the screen. You can find all 4 of them on page, I believe it's 10. And you heard the evidence. I'll be happy to answer any questions you have. To the last point that was just made, there is some medical evidence that's undisputed and, well, does anyone else in the audience, I don't think anyone else was sworn in, but does anyone else wish to speak on this variance application? Madam Clerk, let the record reflect the negative. To the last point, Mr. Chairman and board members, there has been some undisputed medical evidence that there is a disabling condition Ms. Messenger has that can be considered under criteria 2. And I can facilitate this however you like, or I can be quiet, which is my preference. But if you feel the criteria has been met, you can make a motion to approve it. It requires a 4/5 vote, and we'll reduce the writing, the order granting it. If you feel it hasn't been met, you can make a motion to deny it, or you can take it criteria by criteria, 1 through 4.
Well, to put it in the record, after the testimony heard and the evidence given, written evidence given of her physical condition, I believe that meets the criteria of number 3, the variance, number 2, the variance of the Fair Housing Act for a person with a disability. Meeting that particular level, I think, supersedes any other. So, in my opinion, I believe it warrants a variance. So, if we're going to vote on it, I'm going to vote to grant the variance.
I would concur with the chairman's assessment.
Are you making the motion to accept?
I'm making a motion to grant the variance.
I second.
Second it. All in favor? It's unanimous. Well, folks, enjoy your elevator.
Those pictures were very helpful.
Sure. Mr. Cleva, I would like to follow up with you. If the contractor has told your clients that they received a permit, I want to run that down either way.
Yes, sir.
And make sure they know if they're going to do business in the town, they need to pull permits.
Yes, sir. No, I was going to continue that as well.
What's that?
I was going to
Yeah,
follow up.
well,
with-
I don't want folks like your clients to have to deal with this in the future. If they're paying close to $2,000, they're told they're going to get a permit.
Yep.
These people obviously know one's needed, or they wouldn't put in their estimate. So going forward, to the extent we can learn from what's already happened, and
Age or,
let's run that down.
I will, yes, sir.
Okay, thank you.
in other words, Sunset Lift will be held accountable.
I don't want to answer that. I don't have any contractual relationship with them, but what I'm saying is that the evidence was that they have said they obtained the permit. Either there's a disconnect between them and the town, or they need to be reminded that if they want to do business in this town, they must obtain all required permits. I mean, that's just something, we'd be foolish not to learn from what we hear today.
I will follow up with that, Mr. Eason.
And feel free to give them my contact information, because I'll be calling them if I don't hear from them.
Yes, sir.
Very good.
And I don't mean that threatening, I'm just saying,
Need a motion to close the hearing?
Let's do it.
One motion, second, all in favor?
that I don't want
Motion to adjourn,
Done.
to deal with
second.
this.
Vote,
All in
second.
favor, everybody
Unanimous.
raising their hand.
Yeah, my question, how could he have gotten a permit?